Hello, everybody. Hello, hello, hello. Welcome in, welcome in. I know my timing's a little bit off, but that's just how things are going these days. So, hello, welcome. Hi, everyone. Hello. I have a quick live here, just a quick update for everybody. We've got a couple of filings out of the DC case that have just come down. Perfect for you. Oh, excellent. Love that. Would I like some pizza? I would love some pizza right now, John. I would. No, not 7 yet. I've got some time issues tonight. I apologize. This day has just been a very different day for me. So let me go ahead and share here what we're doing. This is the DC case. All right. Hopefully everybody knows what that means. And so it's the Jan 6th case, and we have some new filings here. So we have 2 motions that have been filed. So new motions. I will just put this on my little sticky note here. Hopefully everybody will understand what that means. No worries. Hello. Yes, Mondays are crazy. Oh, they are. Hello, Spoonie. Good to see you. Yes, hi, Laddie. Yes. We have a new filing here from Jack, everyone. A very short motion. I will go ahead and read it and then, of course, explain it as well. It's a little, I suppose it's a little unusual. It's a request to file an oversized motion. So I thought this would be great. Yes, thank you. Thank you, Deborah. Yes, if I did do anything involving a Mr. Diddy, it would be over on my Tube of You, although at this time I'm not planning to go through that case. I think there are plenty of other creators breaking it down, and so I've got plenty of other things that I would prefer to go through rather than that. That particular topic's very difficult as someone who has worked those kinds of cases. So very important case, everyone, but I think there are some creators doing some great work out there. So good afternoon. Hello. Welcome in, everybody. So give us exactly, Sissy, exactly. Now, for those of you that were on earlier today, I was just on briefly just to say hi over the lunch hour, very quick, just to say howdy. I had hoped to come on and do a full live stream tonight on my Tube of You, but honestly, it's not looking like that's going to happen. My some things have changed around in my schedule today, so I thought, well, I better go on when I can. So here we are. Welcome in. Hello, everybody. Yes, so here we go. We have in the DC case, everybody, we have a schedule that has been set out for us. Let me grab my docket here. We have, just to keep everyone up to date, on Thursday, Jack is supposed to be filing his immunity brief here. So this will be the brief where the government sets out how they believe the superseding indictment in the DC, the Jan 6 case, is appropriate and is in compliance with the U.S. Supreme Court's case that was delivered on January 1st. So he is due to file his brief on Thursday. So what we have right now is a filing from Jack asking for permission to have an oversized brief. And this is something that can happen when you have very complicated issues going on in a case. You need to request it. We have page requirements that have to be met, and if you want to exceed those, then you need to ask permission, and that is what Jack has done here. So he's requesting to file an oversized motion here, to file an oversized brief, and Mr. Trump and his team are opposed to that. Very opposed. Their team filed opposition to special counsel's motion for oversized opening immunity brief, and they are very heated in their opposition. So let me go ahead and read through this motion. It's very quick, very short, and then we'll kind of talk about it. So here we go, everybody. We have a government's opposed motion. That means they did ask the other side, and the other side said no, for leave to file oversized motion. In Trump v. U.S., and that's the immunity case, the Supreme Court emphasized the necessarily fact-bound nature of any presidential immunity analysis and quoting the case, determining whose characterization may be correct and with respect to which conduct requires a close analysis of the indictment's extensive and interrelated allegations, end quote. Next quote, the analysis therefore must be fact-specific and may prove to be challenging, end quote. Next quote, knowing, for instance, what else was said contemporaneous to the excerpted communications or who was involved in transmitting the electronic communications and in organizing the rally could be relevant to the classification of each communication, end quote. The Supreme Court remanded to this court to determine the first instance, with the benefit of briefing we lack, whether the defendant's conduct in this area qualifies as official or unofficial. That is the key, everyone. This is what we're looking for. Is it official or is it unofficial? The acts that are put into the superseding indictment. To fulfill the Supreme Court's remand directive in a status hearing on September 5th of 2024, the government proposed filing an opening immunity brief with a comprehensive discussion and description of both pled and unpled facts. So we've got some facts that we have not seen yet, so that all parties and the court know the issues that the court needs to consider in order to make its fact-bound determinations that the Supreme Court has required. The government has also indicated that the proposed brief would include a substantial number of exhibits. So I think we're going to see, this will be essentially, everyone, a little mini trial. We will see facts and evidence being put on by the government. And this will be our first real insight. So it'll be kind of like a mini trial, setting up the major trial here. In a scheduling order entered the same date here, the court ordered the government to file an opening brief on presidential immunity by September 26, which is Thursday. The court has been directed to conduct a detailed, fact-bound, and thorough analysis of the government's case to make appropriate immunity determinations. Because the court will make determinations in the first instance that will be subject to exacting appellate review, it is essential that the court ensure that the record in support of its determinations is complete. The government believes that a comprehensive brief by the government will be of great assistance to the court in creating a robust record, and the government thus seeks leave to exceed the typical limit for a single motion. And that's under Rule 47E, which limits opening motions and oppositions to 45 pages and replies to 25 pages. The government has substantially drafted its opening motion and estimates that the filed version will not exceed 180 pages. That's a lot, everybody. That's a lot. The government estimates that roughly half of its motion will consist of a detailed factual proffer. So that's a lot, everyone. So they've got 90 pages of facts. 90 pages of facts to present to the court. That is a lot. So we are basically going to see a written trial in this motion, is what's going on here, all right? And that extensive footnote citations to an exhibit appendix increase the motion size by more than 30 pages. So again, we've got quite a few exhibits as well. Short novel, exactly. The government conferred with the defense. Defense counsel opposes the government's motion. At this time, requests that the court set a deadline of September 24th, 5 p.m. for the defense's response. For the court's awareness, the opening brief and its exhibits contain a substantial amount of sensitive materials as defined by the protective order. Consistent with the protective order, the government intends to file a motion for leave to file under seal that attaches an unredacted copy of the motion and appendix and proposed redacted versions to be filed later on in the public docket at the court's direction. So we're only going to see a little bit. We will see some things that will be redacted. Yes, it will be publicly available, but it's looking like there will be redacted information. So remember that protective order that has been held constitutional all the way up and all the way back down has protected some information when it comes to witnesses and so on. So some of that will be redacted, but that just means that the public will have access, but it'll be blacked out. Yes, yes. When do you think this will be unsealed? Great question, and I'm not sure. I'm not sure. Because of the extensive and time consuming logistics involved in finalizing the brief, appendix, and proposed redacted public versions of the same, the government respectfully requests the court's decision on this motion as soon as practicable. And then we have this signed Jack Smith. All right, so that is Jack's order. I apologize, everybody. My cat is sitting right next to me, so you may see a tail. You see a tail come in. Oh dear. Now both of my cats are here. Oh my gosh. There's a chance we won't learn anything now. No, we'll be learning. There will be a lot of information coming to us on Thursday, everyone. Now, what size of the brief? Again, the courts tend to be pretty generous in pages. If counsel wants to have an oversized brief, 9 times out of 10, judges will be like, okay, fine. Especially one like this where we're going to have huge appeals constantly, and these appeals will go all the way up to SCOTUS. And so for the government to have a brief for SCOTUS to review as part of that record, I think is very important. So it is nice to have pets around, although Pearl is very close to the camera at the moment. Will the trial be live? No. So because this is in federal court, our federal cases are not live. The hearing that I'm absolutely sure will occur will not be live either. It will be open to the public, but it will not be in a place where the media will be. So we will basically have people in the room telling us what's going on. Does the defense have a say on what gets redacted? So both sides need to approve. What will happen is a redacted copy will be submitted, and then to make sure that the other side agrees with it, and the other side will say yes or no, or add redactions to it, or say we don't think this part should be redacted. So both parties will need to come together on that. Oh, I hope she doesn't sneeze. Don't sneeze on the paperwork, please. Thank you. So yes, we will, both sides, of course, will have some say in it as we go. Now, we do have here the filing. So the filing here from Jack was on the 21st, and then Mr. Trump's team did file on the 23rd. I will go through just the introduction to give you some idea of what Mr. Trump's team is going to be talking about here, but I won't go through and read the entire motion at this time, just because it's pretty repetitive. So as that goes. All right, so I just finished reading Jack's motion to file an oversized motion. So his brief that's due on Thursday has asked for extra pages here, claiming he's got facts that will take up 90 pages alone. So just the facts will be taking up 90 pages, not even the argument, which of course, the argument is very important. So here we go, everyone. Then this is Mr. Trump's response, where he is opposed to that. So here we go. We've got President Donald Trump's opposition to special counsel's motion for Come on, Pearl. Come on. Nope. Come on. Apologize, everybody, for oversized opening immunity brief. So again, this is Mr. Trump's motion because he always writes President Trump on here. Come on down. Let's get down. Thank you. All right. There we go. Off she goes. Yes. My kitties are out today. Oh, did you see the toes? Oh, dear. All right. Well, off they go to play. So here we go. Introduction, everyone. President Donald J. Trump respectfully submits this opposition to the motion by the Special Counsel's Office for permission to file a 180-page opening immunity brief. The motion is a new development illustrating the unprecedented and irregular nature of the office's approach on remand, as they are seeking permission to file a document that would quadruple the standard page limits in this district. The office cites no case in which such relief was granted, just as they cite no authority for the previous request to file a freestanding brief relating to presidential immunity that is not responsive to a pending defense motion. Exactly, exactly. I'm trying to defer the area, everyone. The proposed approach is fundamentally unfair, as the office would attempt to set a closed record for addressing unfiled defense motions by crediting their own untested assessments of purported evidence, denying President Trump an opportunity to confront their witnesses, and preventing the defense from obtaining discovery. The hypocrisy of this proposed approach is demonstrated by the office's earlier arguments in this case and in Florida, that using discovery materials and public filings could taint the jury pool and bias potential witnesses. Their requests are also inconsistent with the federal rules of criminal procedure, and the court should reject them until the threshold legal questions identified by the Supreme Court are addressed and discovery is complete. And we'll flip here. Today, the special counsel's office informed President Trump that they wish to file a SIR reply relating to President Trump's pending discovery motions, which I have started to read but was unable to finish. They should focus on that document and on complying with their obligations rather than pushing this filing to support their politically motivated agenda. The opening immunity brief, as described in the motion, would be an improper special counsel report, masked as a superfluous filing seeking advisory opinions in a criminal case. The document would violate the presidential immunity doctrine, taint the integrity of these proceedings, increase the First Amendment harms resulting from the gag order, and violate the Justice Manual. Accordingly, for the reasons set forth below, the court should deny the motion and grant President Trump's request to reconsider the current schedule. And then we have footnote 1 saying, if the motion is granted, President Trump reserves the right to seek corresponding relief with respect to page limits and the ability to file a SIR reply. So that is Mr. Trump's view on that. So couple of things. We really are in kind of an unusual... There are a couple of unusual things going on here with the DC case, because we are in this zone where the Supreme Court, where John Roberts has created this new defense, all right? So this total complete defense that presidential immunity applies to this official acts situation in a criminal case was just created. All right, so we're trying to figure out exactly how it works. Now, when we were dealing with civil cases, we had case law that came in and said, you can't sue, but we're in a criminal world. And with the Supreme Court, they've just set out a new standard. So they were very vague about the standard, and so we're trying to figure out exactly what they meant. So normally it'd be like you just say, well, look, John Roberts, why don't you tell us what it is that you want? But that would be outside of what we're supposed to do, so we can't do that here. So we've got this pre-trial question coming in now of what acts on January 6th and leading up to and after were official acts and what were unofficial acts. All right, that's the question. That has to be determined. Now, how do you determine that, right? That's the question the Supreme Court said is up to the judge. It's up to Judge Chutkan. She needs to decide. And then once she decides, it'll get appealed. And then once it's appealed to the Court of Appeals for the DC Circuit, then it'll get appealed. And then it'll be, hey, John Roberts, what about this? And he'll say yes or no. And then it'll go back down again. And then they'll go forward that way. So instead of being able to just call Roberts up and say, what are you doing here? Because that would be wrong. We're going to have to take this through the court system here. And Roberts knew that when he wrote the decision. But alas, it's what we have. And one thing in the legal field that we always do is, we got to work with the law that we have. So this brand new law that was set out on July 1st is involving Judge Chutkin needing to assess the facts in this case and assess acts that were involved and make that determination, right? To see what are going to be covered by immunity, what are not. And with really no guidance from the court other than a few suggestions, and that's literally the words they used. They had some suggestions, but that was it. They didn't set it out much more than that. We have an amazing opinion out of the Court of Appeals for the DC Circuit regarding a civil case regarding official and unofficial acts in the Blessing Game case, and they have set out a great set of what official and unofficial is going to look like. But again, we're in a civil world in the Blessing Game case, so we don't have criminal guidance. So we're making precedent here. So here, Mr. Trump's team is saying, you're coming in and you're presenting all of these facts, and we're not able to, counter these facts, although they would have their response, right? Their response can come in and say your facts are wrong. But we're kind of taking it out of the normal scheme of things when we're working in a criminal case, right? You have a right to confront witnesses called against you. And so if they're going to put in information and facts, then, as the defendant, Mr. Trump has a right to confront them. And so what he's saying here is, you're just putting these out in a filing. How are we having a right to confront? Now, that I think is a valid argument and one that needs to be addressed. But I will say, typically in criminal cases, we have situations where we've had defendants ask for further probable cause. We'll use that as an example. So they'll say, you don't have enough probable cause. So they'll ask for a preliminary hearing. So that means then the government has to file more facts and information in order to support their indictment. All of that is public. So and that happens on, regularly. That's something that's part of the process. So this is similar, but just more in depth because, again, we're trying to make this determination on immunity so that John Roberts will have a chance to read through it and pick what he likes and leave what he doesn't like. So, this is more complicated, but still kind of in the same vein. I would give you the example of a bill of particulars. So, in a criminal case, everyone, if we have a defendant that says your indictment's too vague, similar to what has happened in Georgia with the demurs that had been filed, they said, you weren't clear enough and the law wasn't clear enough. So the state can file more information, ask for a hearing, and put on witnesses and information in order to show, yes, there is probable cause. And that would confine the state to be within the four corners of that bill of particulars, but all of that information would be public. So we do have a process pre-trial where information about the case is made available and where a defendant's right to confront is not being violated because it is a part of that pretrial process. So that's what I'm trying to put out here. Mr. Trump they're making the arguments that they should be making when it comes to tainting the jury pool, when it comes to bias. Those are the arguments that an attorney should be making in this situation. But again, we're in a brand new situation where we're kind of shaping and molding a record, a set of paperwork to give to John Roberts ultimately. So, we've got to figure out how much can be included, how much cannot be included, what's going to happen to our potential jury pool, and so on. So this is going to be a bit of a process, everybody. Yes, so Jack is asking for 180 pages. Typically, I believe it's 45 is what's allowed. 45 is the typical amount that's allowed, and he's asking for 180 because of the exhibits that need to be added, the appendix, going through the exhibits, the facts themselves. So he is asking, it's a lot. But again, we're in this brand new place here where we are creating, We are creating all of this, everyone. All of this is not being created for a jury. All of this is being created to put on John Roberts' desk so that he can flip through and pick what he wants and what he doesn't want when it comes to the immunity doctrine. So that's really what's going down here. That's what's happening. And some people may say, well, that doesn't sound right. And, maybe it doesn't sound right, but, there's just reality. Let's just live in reality, everybody. This is all going to be decided by John Roberts because this will all be taken back up to SCOTUS. All right. So we have to kind of balance out having a full, complete record. So Roberts has all the information, but also making sure that we're preserving the eventual chance of this going to a jury. 180 pages, it would be made public except for what needs to be redacted, meaning whatever's covered by the protective order would have to be redacted. Any kind of private, information, those kinds of things would be redacted. I'm not sure it would probably look as redacted, maybe less redacted than the government's filing in the TikTok case. If you'll remember, their filing, like every other line was redacted, and even the judges didn't know what was redacted. So it would look similar to that, maybe a little bit less redaction. I think he's seen any of this evidence already. John Roberts? No, I don't think so. Nope, I don't think he's seen the actual. I mean, he has probably a good idea of what's been in all of the other cases. So he knows all of the other information, the entire indictment that was filed in D.C. He knows all of that. He knows the Anderson case, which was incredibly detailed, where they came down with the 14th Amendment, can only be applied if Congress applies it. So those kinds of things he's already read. But as far as actually seeing the paperwork, like the phone call, like the text message between Meadows and Ginny Thomas, like he'll actually get to see those text messages rather than just hear about them. As will Thomas, because I'm sure he won't recuse himself. So if it takes course and the defendant is no longer on the same planet, what happens? Oh my goodness. The number one thing that you need to have in order to go forward in a criminal case is you need to have a defendant, and they need to be someone that you can point to in a courtroom. So we do have to have that. Don't they normally not tell everything to save some stuff for trial? They do, Mimi. Great point. They do, but there are some situations, like the example of the Bill of Particulars that I was giving you before. There are some situations where your case is you give everything. And as far as facts and evidence goes, you don't really keep any evidence from the defendants. It's just a matter of how you present it to the jury. So you may give the defendants 200 pages of evidence, and you may only use 30 of those pages in front of the jury. But in this case, instead of just using 30 pages, you would then present all 200 pages because you're showing it to a judge. If you guys are all following me there with that. Yeah. We can't have a... Oh, funny. No, I mean, if it's in civil court, then yes, you continue on past your earthly body. Your estate then continues on in your place. But if it's a criminal case, we cannot go forward without an actual body. That's so funny and so relevant. Very important. Yes, I've gone through the motions already, Donna. So again, let me just do a recap here. We have a motion filed by Jack, who is, of course, leading the government team. He's asking to have an oversized motion filed of 180 pages because of the new defense that has been placed into the legal world from the Supreme Court and the nature of the fact-finding piece that Judge Chutkan will need to do in order to satisfy John Roberts. And so he's asking for more pages. Now, Mr. Trump's team is opposing that. because he's saying the information coming out is not in a form where he can kind of confront those witnesses against him, and it could taint the jury pool. Valid arguments, which are valid arguments, but again, we do handle pretrial motions similar to this in other cases. Even though this is a brand new defense from John Roberts that we are working with here. So they are presenting a great reason why they think the oversized motion should not be allowed, and saying, hey, we don't think that's okay. So that's what Trump's team is saying here. Yeah, so that's the overview. Now, the brief itself is due on the 26th here. That's when his brief is due. So it is due on Thursday. So the court has had, this is Mr. Trump's filing was just done today, and then Jack's filing was done on a Saturday. So we definitely have a couple of days here where we're kind of figuring things out. Sentencing for Mr. Trump in the New York case was moved to late November. Sure, you bet. How to get Cannon off the bench? Well, there's an incredible amicus brief that was written by the CREW, CREW, which is an acronym for an organization for ethics in Washington. They have filed an amicus brief with the Court of Appeals for the 11th Circuit explaining why she should be pulled from this case. So they've done a really great job. Do you get an alert for things like this when they get filed? You know, that's funny. I don't actually, everybody. I know I'll make a confession here. I actually just pull the dockets up regularly. I just have certain times throughout the day where I'm like, oh, I wonder what's going on in DC, and I'll just pull the dockets up. Many times people will also message me if something has come out. So they'll say, oh, just got this, just got that. Especially for the New York filings, some people are on a list where they do get alerts. And so they tell me the New York filings were really quite a pain to kind of keep up with. But when it comes to these big criminal cases and in Georgia, I just watch the dockets regularly. That's just kind of part of my fun. Have a cup of coffee, check the DC docket, time for lunch, see how that Court of Appeals is going in Florida. So there we go. Explain that Trump is not, yeah, well, he is, so I can't. I could explain it, but then that would be false. Yeah, I know. A lot of people probably do wonder. I have a list. Actually, let me see if I've got it here. I have a list of, I can kind of give you an idea. I have a list, and I won't show you what's in here. And I have a list of all the cases that I'm following. And they're not all Trump cases. I'm following a lot of cases going on in the world, in the United States. And so throughout the day, I look through and make sure I check each one off, check and make sure. There's a lot of cases for Mr. Trump, civil cases, cases involving his business and various things. So I just check them out. I try to make sure I check his criminal cases probably 3 times a day, and the rest of the cases I check in the morning and in the evening. So pretrial hearing set for this case before the election. No, we're not going to have a pretrial hearing in this case because we have this other immunity situation going on. This is a really kind of a new kind of legal precedent that John Roberts is requesting. And so because of that, we're not doing our pretrial stuff. So organized. I do try. Yes, VC. New York's amazing because you can go in on email and do that. But for me, I am a pen paper person. So it works. So I have to create my own process. But yes, New York has been amazing, all of the information. And it's been really interesting because, Trump has sued Bragg. He's done a lot of stuff. A lot of people have been sued. Jim Jordan. I mean, there's all kinds of defamation stuff going on. So it's all kind of connected. Merrick Garland as head of DOJ. It's a good question, and I don't know. I really don't know. I think every president should choose their own DOJ, and a DOJ doesn't need to be hanging out there forever. I think we always need a fresh face, in my opinion, to keep things going, keep things moving forward. So I would hope she would choose a new one. I would be a big fan of that, and I think most of the legal community would be. Not to say there's something wrong with Merrick Garland. Personally, I may have my own thoughts on that, but legally, what he's doing, whatever. But if you have a new president come in, you usually get a new AG. So that's how I would do it. Jim, so Kamala should choose Jack Smith. Great. That's an interesting point. But, Jack's really got his star is too bright to just be in the U.S. He shines on the world. So I'm not sure that he would want to narrow or dim his star, or perhaps maybe he's ready for a break. Maybe he's ready for a break. He's been working so hard on these cases, and his family's had to deal with a lot. So he may be pulling an Obama and just go to some Caribbean islands for a few years. Be like, I gotta go, man. But he's done some amazing work. I had no idea who Jack Smith was until these cases, but now that I have seen his work and the quality of his work and the quality of his teams, don't get me wrong, Jack's not working these cases alone. This is a team. This is a team that Jack has put together to do these cases, and he's done some really great work. He's done some great work legally. I feel like we need him. Oh, Jennifer, I understand. I understand. I mean, he's done some great work. Waiting for the surfboard picture. Right. I know. But yeah, he's worked hard, and this is only the beginning, everybody. Again, so to give you some idea, we will be hearing about this case for a very, very long time. And as it goes up to the Supreme Court, comes back down, and then goes back up again, and then comes back down, this is going to be an interlocutory appeal nightmare until John Roberts puts a stop to it. And I don't know how far he's going to let it go. I don't know how far he's going to play around with all of this. But when he's done playing, then he'll put a stop to it. But it's going to take some time. And this whole process of shooting it up to the Supreme Court and shooting it back down and trying to get it all sorted can really interfere with an actual criminal trial. So we're going to have to kind of see how it works. So the first one that goes up is going to be the strongest. So keep that in mind. The what Judge Chutkan puts together first is going to be really the most well-rounded, strongest piece. And so after that, it's going to be just kind of carving out pieces here and there and working it. But that's the nature of the legal field, everybody. We come up against a roadblock. We figure out a way to deal with it. We work it into what we need to get accomplished. So the legal field is kind of just this constant back and forth. Can you explain the interlocutory appeal? Interlocutory appeal is an appeal to a higher court for a procedural question in a case, essentially a procedural question. I'll just use that term, rather than appealing it after you have a verdict, right? So the E. Jean Carroll cases, those are just regular appeals. The AG's case for $500,000 or $500 million, that's a regular appeal. The New York 34 counts, that's a regular appeal. Those are just normal appeals. But when your case is open like this, or the Florida case, that's a regular appeal. But when your case hasn't hit a jury yet, like Georgia and like this case, a jury hasn't heard this yet, trial jury hasn't, then any appeal is called an interlocutory appeal because it just means we don't have a final answer. We've got procedural questions. So that's the difference between appeals and interlocutory. So, right. Well, Arizona, that's not how the system works. Like, like, look, if you might as well, you just put anybody's name in, like, oh, they went after Trump. Why didn't they go after, you know, why didn't they go after Harrison Ford? Why didn't they go after me? Why didn't they go after you? Well, because we don't have any crimes. That's why they didn't go after us. So it's like, well, the point is the people they have gone after, if you get indicted, then that's what I'm going to focus on. I'm not going to focus on all of the other people that haven't been indicted because, it's enough. Can we sue Roberts for speedy? Great question. No, I don't think so. I think Roberts at this point is pretty much untouchable. The only way Roberts is going to be brought down is if his own court brings him down, and I don't see that happening right now. So, no, I'm sorry, Harrison Ford. I'm sorry. I'm just trying to think of random people. Like you're like, oh well, why didn't they go after Biden? Well, why didn't they go after Clinton? Why didn't they go after Obama? Why didn't they go after Bush? Why didn't they go after you go after every single person in the House of Representatives? Like, well, what are you talking about? Like grand juries indict and then you go boom, like, okay, if I get a grand jury indictment then we'll go through it, boom, that's how it works. Like random people, well, right, just random people, like, why didn't they go after Snoopy? Like, I don't know, I guess everyone's like, Snoopy's getting away with everything, and everyone's just picking on Mr. Trump. Like, dude, it's a grand jury. I don't know. Like, it's a grand jury made the decision. Like, I didn't make the decision. Oh my gosh. Thank you so much. Shadow, you're so sweet. I appreciate that so much. Yeah, I mean, it's a grand jury. Like, I didn't decide. I didn't decide that. Like, you say, oh, everyone's else getting away with criming. Like, dude, I don't know. Oh my goodness. That's one of my questions. He is innocent. You're right. I apologize, Mr. Ford. Please don't come for me. That would be a scary person to have coming for you. Can you sue Abbott, Paxton, and Cruz? Great question. When we get into this question of our representatives not truly representing us, the way that the law's designed is that we have to go, there are other ways to remove people. The number one way that the framers, that our country's designed to remove these people is by not voting for them. It's a vote choice. That's how you remove them, is you don't put them back into office. And that's how it was designed. And I don't know if that's the best thing or not, but we can impeach. We can, your party can pull you. There can be, like in the House of Representatives, but, you gotta, it's voting. It's all about the voting. So unfortunately, that's, or fortunately, it's supposed to be the people's choice, right? So as a democracy, so that's, that's how you do it. You got to vote. And hopefully, too, you have to take a look as well. Everyone, I've gotten several questions on what judges to vote for. And I just have to tell you, I think this year is so important to know who your judges are for whomever, whichever way you like. If your judges are like, yeah, this, they're doing everything the way I like it, know that and vote for them. If they're not, then know that and don't retain them. The easiest way to figure out what judges you agree with are to go with a party. Look to your party. So if you're a Democrat or a Republican, or if you refuse, if you don't want to be either of those, then go to your independents, all right? Whatever party, go to their website and look up judges, which judges they support, which judges they do not support. You can do that. If you want to go completely nonpartisan, I highly recommend looking at your state bar association. If you go to your state bar association, they will have a list that's nonpartisan of the judges that are in compliance with the law, that have done just good work, are just good judges. So that's another way to take a look at it. So go research your judges, flip that ballot over, make sure you are retaining those. I certainly have a couple of judges that are absolutely atrocious in my neck of the woods that I will not be retaining. And what's so fascinating to me is that people are asking me about these judges, and I'm like, I don't think anyone's ever asked me that before. And I'm like, okay, yeah. No, don't vote for them. Oh, yes, I will post this. I will be posting it. Yes, this one was kind of like a last minute. This was the time that worked for me today. So look it up though. Look it up. This is really important because there are a lot of judges doing a lot of things right now, right? Like, are you happy with your Supreme Court in Georgia? Are you okay with your courts in Utah? Is everything going all right with how you're looking at your courts in Michigan? Like, this is important. This is important stuff. So most of the judges don't have opposition. It's true. And if they don't have oppositions, you still put in do not retain. And depending on how things work, if they do not get retained, then the whole process gets started again, which means someone has to get nominated, someone has to get put on the court, and then they have to be determined whether or not they're retained. So they don't necessarily have to be running against another judge to still get pulled from the court, depending on where your jurisdiction is and how your state handles it. So even if your judge isn't running against someone, if you don't like them and it's a yes or no question, then it's no. All right, then it's no. If you only have that judge and no one else, then you can leave it blank or write in like, I'll be a judge because I'm smarter than this guy. Refusing to vote. But right. Yeah, no, I think it's great, Jennifer. I love how let's shine a light on these judges, right? It's actually up to you. You have a huge amount of power when it comes to judges. It's just a matter of knowing who they are and knowing which ones are, going with it and which ones aren't. So yeah, we've never really a lot of people don't ever look at judges. And I have a sign that I would always put in my yard that said, they're all great, and then the judges in my area. That's typically that's typically the sign I had put in my yard, but that will not be my sign this year. No. There are a couple of judges that need to go in my area. So so that sign won't be going up, but I keep it. I keep my sign because hopefully, again, we'll get to a point where they're all great will work again. I would love that. So, yes, I will put this up on my Tube of You. I have not been able to get my last live that I did on a motion Mr. Trump did. I had meant to get that up, but I've not been able to get it downloaded. I've tried and tried. But will I still be on my Tube of You later? And I will not, everybody, and I apologize. My schedule for today changed. That's why I was like, if I've got to get on right now, if I'm going to be able to get on at all. So I apologize for that. I will absolutely be doing another Tube of You live. And in fact, everyone, my primary plan here will be, I will probably give a couple paragraphs of Mr. Trump's filings, but I am going to be moving his filings over to my Tube of You. So rather than doing his filings over here, because I'm running into too many dings on my account. I'm just having too many problems. So most of his paperwork I will be reading over there. So I will absolutely be over streaming there for sure. Yeah, I think it's important. I think signs are important for your judges too, right? I mean, keep your judge or, like this judge is bad. So do that as well. Oh my gosh. But yeah, I'm needing to be a little bit careful here with my account because of some things that have been going on with the TikToks. So, I've got to keep it real careful. So, and I'm not trying to scare anybody off here. I'm going to, of course, keep everybody up to date on everything that's going on. But as far as reading through the entirety of Mr. Trump's motions, those I will be now doing almost exclusively over on my TikTok live. So I'll probably do multiple motions but I'll be doing it on my Tube of You lives. But I will keep everybody up to date on what's going on with all of the paperwork, okay? Yeah, the signs do look pretty messy. I don't put signs up other than the judges. So the judges are the only ones, and it's usually because, and I'll be honest, everybody, I'm in a small community. I'm in the middle of the United States in that central time zone, and I'm in a small community. And so people know that, an attorney lives in this house, and so they can come by and they can see are we thumbs up or thumbs down for our judges? And so that's just something that's kind of become a tradition. They can swing by and see what my thoughts are without having to stop me and talk to me, which is great. So I do not have usual times, Kiki. I had before usual times, and then my schedule got thrown off. But starting October 1st, I will have a full schedule out, because I am going to be doing 50% of my paperwork now over there. So I will be setting out days just for that. Yes, they are. See, Kennedy is going to SCOTUS to have him put on. Yeah, he's trying to be pulled from some ballots, but put on other ballots. It's fascinating. It's a fascinating play on how that's working. Interesting. Yes, I'm going to need to get back to a pretty steady calendar. Starting October 1st, I had planned to fully launch my Tube of You much more consistently come October. So October 1st will be the date of the full-time Tube of You. So we will have that up and running. Yes. Well, we will see what happens, everybody. So I will go ahead, though, and I will put this live up on my Tube of You as soon as I can. I will, after we finish this live, I will download, then try to upload. And, TikTok is the one that keeps track of kind of what's going on here. So, but I have uploaded TikTok is the one that keeps track of kind of what's going on here. So, but I have uploaded another post to my Tube of You today. I also have Instagram, which I have uploaded there as well. I don't upload there very often, but I do try to at least keep my finger on the pulse over there. But because there are some things going on with this app. But this one I will have uploaded hopefully within the next 24 hours, so you can look for it there. But thank you, everybody, for coming and hanging out with me at this weird, odd time. I really do appreciate it. This was just what worked out for me today. It was kind of a weird scheduling change situation, kind of a last minute. So I will go ahead and sign off for now and keep you all posted on what the judge decides on these motions. So I wish you all the very best. Take care, and I will be back as soon as I can. So have a good one, everyone.